When to ask about citizenship or residency status 1. At listing appointment or initial contact, ask early, ideally before listing the property. This gives time to plan for FIRPTA obligations before going under contract. 2. Before accepting an offer. If it wasn't clarified earlier, do it before the buyer signs anything, especially in states where agents fill out the residential seller disclosure or FIRPTA addendum. 3. During escrow, if not yet disclosed. If you realize FIRPTA may apply during escrow and haven't asked yet, ask ASAP. You may need to revise escrow instructions or consult a tax advisor. How to ask about citizenship or residency status. You want to be professional, neutral, and compliance-focused, not personal or invasive. Try something like, to comply with federal FIRPTA regulations and properly structure the transaction, I need to confirm whether you are a U.S. citizen or a U.S. resident for tax purposes. This helps determine if any tax withholding will apply when the property sells. Or, the IRS requires buyers to withhold taxes when purchasing from a foreign seller under FIRPTA. Can you confirm whether you are a U.S. citizen or lawful resident for tax purposes? If not, there may be special forms or steps we'll need to follow. Also, emphasize that this is routine and not meant to pry. Documentation to request if needed. If they say they're not foreign, they should be able to provide OA, completed Form W-9, includes their name and TIN. If they are a foreign seller, they may need to O, apply for a U.S. TIN, if they don't have one, O, possibly file Form 8288B, to request reduced or no withholding, O, consult a tax advisor. Or why this matters: buyer is liable for FIRPTA withholding, but if you represent the seller and don't bring it up, you could face disciplinary action for negligence. Helps prevent closing delays, escrow issues, or IRS penalties for failing to withhold. The earlier it's addressed, the smoother and less stressful the deal. Verbal script, listing appointment or phone call. As part of preparing your property for sale, I need to ask a quick but important question related to IRS tax requirements. Are you a U.S. citizen or lawful U.S. resident for tax purposes? I ask because there's a federal law called FIRPTA, the Foreign Investment in Real Property Tax Act, that may require the buyer to withhold a portion of the sale price if the seller is a foreign person. This isn't about your immigration status, and it's not reported to immigration. It's strictly for tax compliance. If FIRPTA applies, we just need to plan ahead to make sure everything goes smoothly. Agents act as a crucial first line of defense in FIRPTA compliance by spotting potential foreign sellers and ensuring the buyer is aware of their withholding responsibilities. While the buyer bears most of the liability, an agent's failure to recognize or disclose FIRPTA issues can lead to legal or disciplinary consequences. During the listing process, a real estate agent's responsibility regarding FIRPTA, Foreign Investment in Real Property Tax Act, is primarily about identifying potential FIRPTA situations early, providing accurate disclosures, and ensuring all parties are aware of their obligations. Here's a breakdown. Key agent responsibilities. Under FIRPTA. 1. Ask about seller's status early. Agents should inquire about the seller's citizenship or residency status as part of the listing intake. While agents cannot give legal or tax advice, they can ask whether the seller is a U.S. citizen or resident alien for tax purposes. This is often included in the listing paperwork or a seller questionnaire. 2. Disclose FIRPTA requirements. If the seller is a non-resident alien or foreign entity, the agent must disclose that FIRPTA may apply and that the buyer may be responsible for withholding and remitting taxes to the IRS. 3. Avoid giving tax or legal advice. Agents should never advise clients on how to avoid FIRPTA or what forms to use. Instead, they should recommend that both buyer and seller consult with a qualified tax professional or attorney familiar with FIRPTA. 4. Coordinate with title and escrow. Ensure the title or escrow company is aware of the potential FIRPTA issue early in the transaction so they can prepare to handle withholding and IRS form filings, e.g., Forms 8288, 8288A, 8288B. 5. Help ensure proper documentation is collected. While agents don't collect or verify IRS forms, they should make sure the seller completes a W-9 or W-8 BEN, depending on their status. This helps determine whether FIRPTA applies. 6. Include FIRPTA language in contracts. Most standard Arizona purchase agreements, like AAR contracts, include FIRPTA clauses. The agent should make sure these clauses are not removed and that parties are aware of their meaning. 7. Stay aware of deadlines. If a seller is applying for a withholding certificate to reduce or eliminate the 15% withholding, the agent should track those deadlines closely to avoid closing delays. The newly revised Arizona AAR purchase contract explains and discloses FIRPTA. Why asking about citizenship, residency status is not a fair housing violation when done correctly. Under fair housing laws, it's illegal to discriminate in housing based on national origin. But asking about citizenship or residency status for tax compliance reasons, like FIRPTA, is not considered discriminatory, as long as it's done uniformly and solely for legal and transactional purposes. Why it's allowed. FIRPTA, Foreign Investment in Real Property Tax Act, is a federal tax law, and it requires buyers and their agents to determine if the seller is a foreign person under IRS definitions. The IRS uses citizenship or residency status to determine if FIRPTA withholding applies. Asking this question is about complying with tax law, not making housing decisions based on where someone is from. How to ask it properly. Use neutral, business-like language. Explain why you're asking, for FIRPTA compliance, not personal reasons. Ask all sellers the same way during your listing intake process to remain consistent and avoid claims of bias. Example: as part of our legal duty to ensure the transaction complies with IRS regulations, I need to ask whether you're a U.S. citizen or a resident alien for tax purposes. This is related to FIRPTA requirements that may apply if you are considered a foreign person under U.S. tax law. Bottom line, it's not about where the seller is from, it's about where they are a tax resident. As long as you're not using the information to discriminate and you're asking for legitimate legal compliance, it's not a fair housing violation. FIRPTA seller exemptions. The $300,000 rule and buyer occupancy. Under FIRPTA, Foreign Investment in Real Property Tax Act, buyers are normally required to withhold 15% of the sale price when buying U.S. real estate from a foreign person. However, there are exemptions, and one of the most common is the $300,000 occupancy exemption. This has been taken from the IRS website regarding the rules of FIRPTA exceptions. Generally, FIRPTA withholding is not required in the following situations. However, notification requirements must be met. 1. The buyer, transferee, acquires the property for use as a residence, and the amount realized, sales price, is not more than $300,000. The transferee or a member of the transferee's family must have definite plans to reside at the property for at least 50% of the number of days the property is used by any person during each of the first 2 12-month periods following the date of transfer. When counting the number of days that the property is used, do not count the days the property will be vacant. For this exception, the transferee must be an individual. 2. The property disposed of is an interest in a domestic corporation if any class of stock of the corporation is regularly traded on an established securities market. However, this exception does not apply to certain dispositions of substantial amounts of non-publicly traded interests in publicly traded corporations. 3. The disposition is of an interest in a domestic corporation, and that corporation furnishes the transferee a certification stating, under penalties of perjury, that the interest is not a U.S. real property interest. In most cases, the corporation can make this certification only if either of the following is true. O, during the previous 5 years, or if shorter, the period the interest was held by its present owner, the corporation was not a U.S. real property holding corporation, USRPHC. O, as of the date of disposition, the interest in the corporation is not a U.S. real property interest by reason of Section 897C. 1. B of the Code. The certification must be dated not more than 30 days before the date of transfer. 4. The seller, transferor, gives the transferee a certification stating, under penalties of perjury, that the transferor is not a foreign person. The certification should contain the transferor's name, U.S. taxpayer identification number, and home address, or office address, in the case of an entity. The transferor can give the certification to a qualified substitute. The qualified substitute gives the transferee a statement, under penalties of perjury, that the certification is in the possession of the qualified substitute. For this purpose, a qualified substitute is a. the person, including any attorney or title company, responsible for closing the transaction other than the transferor's agent, and b. the transferee's agent. 5. The transferee receives a withholding certificate from the Internal Revenue Service that excuses withholding. See withholding certificates later. 6. The transferor gives the transferee written notice that no recognition of any gain or loss on the transfer is required because of a non-recognition provision in the Internal Revenue Code, or a provision in a U.S. tax treaty. The transferee must file a copy of the notice by the 20th day after the date of transfer with the Ogden Service Center, P.O. Box 49101, Ogden, UT 84409. 7. The amount the transferor realizes on the transfer of a U.S. real property interest is 0. 8. The property is acquired by the United States, a U.S. state or possession, a political subdivision, or the District of Columbia. 9. The grantor realizes an amount on the grant or lapse of an option to acquire a U.S. real property interest. However, the transferee must withhold on the sale, exchange, or exercise of that option. 10. The disposition is of an interest in a publicly traded partnership or trust. However, this exception does not apply to certain dispositions of substantial amounts of non-publicly traded interests in publicly traded partnerships or trusts. Certifications. The certifications in items 3 and 4 above are not effective if the transferee, or the qualified substitute, has actual knowledge or receives a notice from an agent, or substitute, that the certifications are false. This also applies to the qualified substitute statement under item 4 above. If the transferee, or the substitute, is required by regulations to furnish a copy of the certification or statement to the IRS and the transferee, or the substitute, fails to do so in the time and manner prescribed, the certification, or statement, is not effective. Liability of agent or qualified substitute if the transferee, or the substitute, receives a certification discussed in item 3 or 4 above, or a statement in item 4 above, and the agent or substitute has actual knowledge that the certification, or statement, is false, or in the case of 3 above, that the corporation is a foreign corporation, the agent or substitute must notify the transferee, or the agent and substitute will be held liable for the tax. The agent's substitute's liability is limited to the compensation the agent substitute receives from the transaction. An agent is any person who represents the transfer or transferee in any negotiation with another person or another person's agent relating to the transaction or in settling the transaction. A person is not treated as an agent if the person only performs one or more of the following acts related to the transaction: receipt and disbursement of any part of the consideration, recording of any document, typing, copying, and other clerical tasks, obtaining title insurance reports and reports concerning the condition of the property, or transmitting documents between the parties, A withholding agent is personally liable for the full amount of FIRPTA withholding tax required to be withheld, plus penalties and interest. A withholding agent is any person having the control, receipt, custody, disposal, or payment of income that is subject to withholding. Generally, the transferee who pays an amount to the foreign person subject to withholding must do FIRPTA withholding. References, related topics. FIRPTA withholding. Reporting and paying tax on U.S. real property interests. Withholding certificates related to U.S. real property interest. Applications for FIRPTA. Withholding certificates. Definitions of terms and procedures unique to FIRPTA. Note: this page contains one or more references to the Internal Revenue Code, IRC, Treasury regulations, court cases, or other official tax guidance. References to these legal authorities are included for the convenience of those who would like to read the technical reference material. To access the applicable IRC sections, Treasury regulations, or other official tax guidance, visit the Tax Code, Regulations, and Official Guidance page. FIRPTA applies to foreign sellers. Facts: the seller of the property is a Canadian national, and the buyers are purchasing the home as a primary residence for their son. Issue: are the buyers required to withhold up to 15% of the purchase price pursuant to the Foreign Investment in Real Property Tax Act, FIRPTA? Answer: see discussion. Discussion: unless an exception applies, when the seller of real property is a foreign person, such as a non-resident alien, the buyer must withhold up to 15% of the amount realized from the sale, which is usually the gross purchase price, pursuant to FIRPTA. Section 3I of AAR's Residential Resale Real Estate Purchase Contract likewise provides that buyer and seller acknowledge that if the seller is a foreign person, the buyer must withhold a tax equal to up to 15% of the purchase price unless an exemption applies. Ordinarily, withheld funds are deposited with the escrow company and then paid to the Internal Revenue Service. FIRPTA further provides that a buyer's failure to comply with the withholding requirements may result in the buyer's own liability for any taxes owed by the seller. Upon filing a tax return, the seller may be entitled to the return of some or all of the amount withheld. One of the more commonly used exceptions applies when the amount realized from the sale is not more than $300,000, and the buyer, or a member of the buyer's family, intends to reside in the home at least 50% of the time in the 2-year period immediately following the sale. In this case, it appears that this exception will apply. The sales price is considerably less than $300,000, and the buyers are purchasing the property as a residence for their son. However, both parties should consult their own independent legal and tax advisors regarding this issue. Taken from Aaron Line. Know your client. If a real estate agent fails to find out whether the seller is a foreign person under FIRPTA, Foreign Investment in Real Property Tax Act, there are several potential legal and professional risks, including 1. Disciplinary action or license issues. Negligence, state real estate commissions, e.g., ADRA in Arizona, may consider the agent negligent for failing to recognize and disclose potential FIRPTA obligations. Failure to disclose material facts. FIRPTA compliance is considered a material aspect of the transaction. Not identifying a foreign seller could be a violation of professional conduct rules. 2. Civil liability. Buyer liability. The buyer is legally required to withhold the appropriate amount if FIRPTA applies. If the buyer fails to do so because the agent did not properly identify the seller as foreign, the buyer could sue the agent for damages or losses, including IRS penalties. Breach of fiduciary duty. If the agent represents the buyer and fails to inform them about FIRPTA obligations, they may be sued for breaching fiduciary duties of care and diligence. 3. IRS penalties, indirect risk via escrow or role as withholding agent. If an agent or escrow officer is considered a withholding agent, having control over funds, and they knowingly ignore FIRPTA responsibilities, they can be personally liable for the full tax due, penalties and interest. 4. Transaction delays or cancellation. Discovering FIRPTA obligations late in escrow may delay closing due to uncollected forms or withholding issues require amended escrow instructions lead to cancellations if buyers feel misled or unprepared. Five, reputational damage. Being known as an agent who mishandles FIRPTA issues can damage an agent's credibility with clients, brokerages, title companies, and other agents. The bottom line for agents: you are not required to give tax advice, but you must ask early, identify red flags, and refer clients to professionals. FIRPTA obligations are federal tax matters, but agents act as the first line of defense by catching it at listing or early in the deal.